Thank you, Mr. Chairman. Judge, good to see you again.
Good to see you, Senator.
We don't have a lot of time, so let me just get straight into it. Senator Cruz was asking you at the end of his time in questionings about United States versus Stewart. This is the case where Neil Stewart tried to cross state lines to rape another person's 9-year-old daughter. He had 6,700 images and videos of egregious and brutal child pornography. The government recommended 97 months. The guidelines said 97 to 121 months. You came in at 57 months. Senator Cruz asked you why. The chairman wouldn't let you answer. I thought maybe you'd like to answer now.
Thank you, Senator. No one case can stand in for a judge's entire record. I have sentenced more than 100 people in a variety of egregious circumstances. In every case, and especially cases that involve the kinds of acts that you're talking about, the kinds of evidence that I had to deal with as a judge, in every case, I am balancing the factors that Congress has determined are appropriate and required for a judge to make a determination. The data points that Senator Cruz pointed to that you may have in front of you don't account for all of the information that was before me as a judge and the authority that you all, Congress, and your prior confirmation when I was a district judge provided for me to exercise my judgment, and I treated those cases and every case very seriously and imposed a sentence that was sufficient but not greater than necessary to promote the purposes of punishment.
Would it surprise you to learn that Mr. Stewart's a recidivist? He was warrants issued again for his arrest just 3 years after you sentenced him.
Would it surprise me?
Yeah, would it surprise you?
You know, Senator, there is data in the Sentencing Commission and elsewhere that indicates that there are recidivism, serious recidivism issues. And so among the various people that I've sentenced, I'm not surprised that there are people who reoffend. And it is a terrible thing that happens in our system.
Yeah, indeed it is. Let me ask you about the Hawkins case. You and I talked about this yesterday. You've been able to think about it overnight. This is a case where you had an 18-year-old who possessed and distributed hundreds of images of 8-year-olds and 9-year-olds and 10-year-olds, and you gave him, frankly, a slap on the wrist sentence of 3 months.
Senator,
do you regret it?
I don't remember whether it was distribution or possession. In
it was
the law,
both. Do you regret it?
In the law, there are different crimes that people commit.
Judge, you
in
gave
this
him
area.
3 months. My question is, do you regret it or not?
Senator, what I regret is that in a hearing about my qualifications to be a justice on the Supreme Court, we've spent a lot of time focusing on this small subset of my sentences, and I've tried to explain.
You regret that we're focusing on
times,
your cases? I don't understand.
No. I'm talking about the fact that you're talking about
child pornography
7
cases?
Very serious cases.
I'm glad we agree on that. Don't you think we should be focusing on that?
Some of which involve conduct that I sentence people to 25, 30 years.
3 months in this case, Judge. Do you regret it? You haven't answered my question yet.
Senator,
do you regret this sentence?
Senator, I would have to look at the circumstances. What I'm telling you...
You know the circumstances. We discussed it for half an hour yesterday. There's a 55-page transcript, which I'm sure you've read. You lived it. As you've emphasized to this committee over and over, you've lived it, right? You said that you've been through all of this. You've looked at all of the images. You're the one who's had to endure all of it. You gave him a 3-month sentence. I just wonder if you regret it or if you stand by it. I mean, do you stand by that sentence?
Senator, in every case, I followed what Congress authorized me to do in looking to the best of my ability at all of the various factors that apply, that constrain judges, that give us discretion, but also tell us how to sentence. And I ruled in every case based on all of the relevant factors.
So you don't regret it?
No one case, Senator, can stand in for a judge's
I'm not asking you that. I'm asking you if
record.
you regret this sentence in this case. And it sounds like the answer is no. But I want to tell you I regret it. I regret that you gave him only 3 months. Let me read to you what you said about these kinds of cases, and in fact, to this defendant. You said, "Make no mistake, Mr. Hawkins, the children you saw in those pictures were not willing participants in the conduct that you witnessed. They were being forced to commit unspeakable acts of sexual violence for the pleasure of the person who was filming and for the gratification of sick people everywhere, people who apparently have no shred of empathy for what this must be doing to the children who are being abused in this way." You go on. Some of the children you saw in those pictures will never have a normal adult relationship. Some of them will turn to drugs and prostitution and other vices to try to deal emotionally with the pain that results from the torture that they have experienced. And even those who manage to lead a somewhat normal adult life say they live in constant fear of being recognized. Some people are even unable to leave their houses because once those pictures are on the internet, they are there forever. And the victims can't do anything without worrying that every person that they meet has seen them in their most vulnerable state at the most horrible time in their lives. That's your words, pages 34 and 35 of the transcript. Powerful words, Judge. I just don't understand why after saying this and believing this, you could give this guy 3 months in prison when the probation office that we've heard so much about recommended 18 months. Even the probation office recommended 18 months. Do you have anything to add?
No, Senator.
Let me ask you about your policy of not giving enhancements when there are prepubescent children, like there were in the Hawkins case, who are 8, 9, 10 years old, when there are prepubescent children involved. I'm just struggling to understand this. You said it in Hawkins. You said that you weren't going to give him an enhancement. You weren't going to make his sentence any tougher, despite the fact that we had all of these terrible videos that you and I talked about at length yesterday. This is page 38 of the transcript, just so that we're all following along. You said, "In your case, I don't feel that it is appropriate necessarily to increase the penalty on the basis of your use of a computer," and we've talked about that, "or the number of images or prepubescent victims as the guidelines require, because these circumstances exist in many cases, if not most, and they don't signal an especially heinous or egregious child pornography offense." You said the same thing in the Cooper case just last year. This was an individual, Cooper, who was 30 years old at the time of his sentencing. He pleaded guilty to distributing child pornography. He posted between 3 and 4 dozen images of child exploitation to Tumblr, where it could be accessed publicly. The government said, and I'll quote from the transcript in that case, page 37, when his devices were found, including the computer, within the computer and on an untitled folder were many, many, many videos. The nature of these videos went well beyond mere child pornography. The government says, I don't mean to make light of the content of any child pornography, but rather to say that the content of those videos is on the more egregious or extreme spectrum of the child pornography videos that are encountered in these cases. And yet, when you sentenced him, you said, I'm quoting now from the transcript in Cooper, "I'm really reluctant to get into the nature of the porn." And then later, "It's very difficult to assess how different Mr. Cooper's images are than those of other similarly situated child pornography defendants, such that I, without going into looking at them, and I'm not an expert," you say. So you say, while I understand the government's arguments, Mr. Miranda, the government's arguments in that regard, I don't find them persuasive from the standpoint of characterizing this as an especially egregious child pornography offense. Help me understand this, Judge. Why is it that what's your policy disagreement with the guidelines treating images, videos, pornographic images that have small children, infants, 7, 8, 9-year-olds? Why won't you give an enhancement for those? Help me understand that.
Thank you, Senator. I'll make 2 responses. First, that's not my policy disagreement. I don't know why you've characterized that in that way.
Well, wait a minute. You say right here in the cases. I mean, this is what I want to make sure that we're talking about the same thing here. This in the Hawkins case, I don't feel that it's appropriate necessarily to increase the penalty on the basis of your use of a computer or the number of images or prepubescent victims. And you say the same thing in Cooper.
Senator, 2 observations. One, I am sentencing in every case. I have policy disagreements with certain aspects of the operation of the guidelines that I lay out in every case as Congress has required and as the Supreme Court permits in light of my experience, not only as a district judge, but also on the Sentencing Commission, which did a report about the operation of the guidelines. Second, you've read extensively from the government's argument in this case. You've not provided information from the probation office or the defense. And when
I don't have the probation office report.
No, excuse me, Senator. The probation office provides a recommendation. There has been information gathered about what a recommendation was given in each one of these cases. I don't have that information here, but what I'm saying is that in every case, the judge is not just hearing from the government. The judge is not just evaluating what the government says in these cases. In every criminal case, a judge has to take into account all sorts of factors, including arguments being made by the defendant, by the government, by the probation office. So I understand that in certain cases, the government may have made an argument, but there are other people in our criminal justice system who make arguments, and the court evaluates everything as Congress has directed, and no one case can stand in for my entire record of how I deal with criminal cases, or did when I was a district judge. I have law enforcement in my family. I am a mother who has daughters who took these cases home with me at night because they are so graphic in terms of the kinds of images that you are describing. They give you not only the actual videos, which you can ask to see, but they describe in the briefs in detail what these videos show. So I am fully aware of the seriousness of this offense and also my obligation to take into account all of the various aspects of the crime as Congress has required me to do, and I made a determination seriously in each case.
What I'm trying to understand is, why is it that you say multiple times that just because there are prepubescent victims in Cooper, in Hawkins, that does not signal that this is a heinous or egregious child pornography offense, and you're not going to apply any sentencing enhancements that the government's asking you for? The sentence gets to be less because you say, I'm not going to apply. The government asked for enhancements related to prepubescent children, related to the nature of these images. You say, I'm not going to apply it. But what you're telling me is, I guess, that you don't have a policy objection. I mean, why didn't you apply the enhancements as they were asked for?
Senator, I've answered this question many times from many senators who've asked me, so I'll stand on what I've already said.
So you have nothing to add about why these crimes, why these images, in your view, do not signal an especially heinous or egregious child pornography offense? That's Hawkins. You say in Cooper, I understand the government's argument, but I don't find them persuasive, the fact that there were prepubescent children, from the standpoint of characterizing this as an especially egregious child pornography offense. That's page 58. Let me ask you this. You said to Senator Graham earlier today that you were trying to do what's rational, and you didn't in sentencing in these cases, and you didn't think it was rational to sentence people who had thousands of images by using a computer to the sentencing guidelines, to the mandatory range. I'm sorry, it's not mandatory, to the no longer mandatory range, the discretionary range.
No, Senator, I said the guidelines system is designed to be rational.
Okay, so let me ask you this. Why isn't it rational to sentence people who have thousands of images on a computer to more time as opposed to somebody who has one or two pictures in the mail? In other words, the more images there are, why wouldn't you want to sentence that person to more time rather than less? Why isn't that rational?
Senator, I've answered this question, and I'll stand on what I already answered.
So, but your answer is what? I mean, refresh my memory.
Senator, I've answered this question. I've explained how the guidelines work, and I'll stand on my answer.
But the guidelines are not mandatory. I wish they were, but they're not. The Supreme Court made that determination. I'm trying to understand why you think it's rational not to sentence criminals based on the number of images they have. You say that this is a policy disagreement that you have with the guidelines. This gets to the core of your judicial philosophy. You served on the Sentencing Commission where you recommended changes to the guidelines based in part on this policy disagreement. So I think it's relevant and indeed vital we understand what the policy disagreement is. That's what I'm trying to get at here.
Senator, I previously explained what the policy disagreement is, and I will stand on my answer.
So you're not going to answer my question?
No, I've answered your question in my answer.
You haven't answered my question. I'm sitting here asking you, and you're declining to answer.
I've explained how the guidelines work. I've explained that the guidelines were developed at a time in which the commission of this crime was different than it is today. I've explained that Congress has not intervened to revise or direct the commission around how to deal with the changes in the commission of this crime. And so judges all over the country are grappling with how to apply this guideline under these circumstances. And there's an extreme amount of disparity. And in each case, a judge has to look at all of the factors, not just the guidelines, not just what the government asks for, but the recommendations of the probation office, the arguments of the government and the defense, the nature and circumstances of the offense, the history and characteristics of the defendant, the need for the sentence imposed to promote the purposes of punishment, which include things like rehabilitation. Also, in every case, Congress has authorized judges to impose not only terms of imprisonment, which are a very important part of the consequences for these crimes, but a range of other preventative kinds of measures which courts impose in cases to prevent these defendants from repeating these egregious, this type of egregious conduct. And I talked to each defendant, as you have quoted, explaining to them the harms that their crimes caused, and I imposed not only a term of imprisonment, but also all of the other consequences of the offense, to include decades of supervision, restrictions on use of a computer, and the like. That's my answer. I've answered it many times. Do you have other questions for me?
Yeah, I do. I do, because I want to try to understand when you talk about the guidelines being outdated and outmoded. I understand that they were written, the initial guidelines were written at a time when computers were not common. Everybody didn't have one. Certainly didn't have phones in every pocket like we do now, smartphones. So I understand that. I also understand that the number of images, sexually exploitative images of children on these devices has exploded. And so I'm trying to get at what Senator Coons earlier characterized as a pretty fundamental policy question, which I think is the correct characterization here. I'm trying to understand your view on why it is that while the number of images available on these things has exploded, that sentencing shouldn't track that. You see what I'm saying? I mean, you've made the argument, if I understand you right, and I want you to correct me if I'm wrong, you've made the argument that, well, look, the guidelines were written at a time when this stuff was like, it was an individual picture, it was, you know, magazines, whatever. Now, almost every offender, I think this is the argument, so you correct me. Almost every offender, because of the nature of this, they've got tens, hundreds, sometimes thousands. I mean, partly because of the nature of this. My question to you is, wouldn't we want to deter that? Isn't that a reason to impose tougher sentences? I mean,
Senator,
go ahead.
The Congress has every ability to do that. What's happening now is that you have a guideline that has gradations in it for the number of images that ends up being, when you look at the scale, something like the difference of 10 years. I don't know exactly what it is, but each two-level enhancement is like several years. And the gradations are like 0 to, and again, I don't have it in front of me, but it's like 0 to 50 pictures, 50 to 100 pictures, 100 to 150 pictures, set up at a time in which the mail was the primary mode of possession and distribution. And so if somebody had 50 pictures, they, according to Congress and the commission at the time, deserved an extra 10 years in prison. Now, with that scale, everybody's at the top immediately, just because of the nature of the internet. So you're not differentiating using that scale anymore, given the way this crime is committed. And so judges are having to decide, how are we going to deal with the penalties and do our jobs to impose sentences that are sufficient but not greater than necessary under these circumstances.
Yep. Thank you, Judge. I'll just say in closing that I appreciate that answer, and I understand that as a policy matter. I just think we disagree. I think that somebody